Right, 8 o'clock on the dot. My name is Jacqui Brauman from TBA Law. I am the principal solicitor. I'm an accredited wills and estate specialist. And tonight we are doing a webinar on estate planning horror stories. So I'm going to switch over and show my slides soon. A few people will still be coming in as I'm talking. You will get a replay sent to you. If you have any questions, you're able to enter them. I will come back to this screen at the end. I won't see them throughout the webinar. So I'll answer any questions at the end. Or if you're watching a replay, they will be emailed and I will answer them. So let's jump straight in. Share my screen. And there you go. You should be seeing my slides. So, claims against estates, horror stories. So, tonight we are talking about where estate planning has gone so wrong that there's been court action, basically. So it has caused a massive problem and certainly a big expense. So, sorry, moving along. This is me. As I said before, my name is Jacqui Brauman. My business is TBA Law. I'm the wills and estates solicitor, or the main one. Our firm does other areas of law as well, but I got my master's degree in applied law a couple of years ago after having worked in the legal industry for about 10 years. And then I went through a 12-month program with the Law Institute of Victoria to become an accredited specialist. So there's about 22,000 solicitors in Victoria, and there's only about 80 of us with a wills and estates accreditation. But I am not only a lawyer. As you can see tonight, I'm in my home. I am a person as well. There are a whole lot of novels behind me on the bookshelf, and up the top there's a whole lot of boxes which were all full of fishing reels. And you can see in the photo on the screen that my husband and I get away with our dog on our boat as often as we can. In that photo, it was probably about this time last year, and we're on Eildon. So, estate planning. It's very different from what it was 70 years ago or even 50 years ago. We're living longer. We have more assets. We accumulate more. We invest more. We have more blended families. So we're not a simple nuclear family that owns a house and some money in the bank. We have often multiple properties. We have superannuation these days. We often have a family trust where we've invested. We also tend not to die suddenly these days. We tend to have an illness or a long period of decline mentally or physically. So it's more likely that powers of attorney are going to be needed so someone can help, and appointing someone to make medical treatment decisions for you if you can't anymore. So there's more and more things to consider. The level of debt that we have is often more significant as well. So we also need to be looking at life insurance. People with young children need to look at appointing guardians appropriately. And we also need to be thinking about making sure that our beneficiaries are inheriting in the best way possible. So, bearing that in mind, tonight I'm going through some case studies, about 10 fairly recent cases that have been through the Supreme Court, mainly in Victoria, in the last 5 years or so. So, there has been, a lot of change, particularly in Victoria in the last 5 years, around disputes about estates. Primarily because there was almost open slather for people making claims against estates for provision, which is a different form of a claim against an estate. Because the law in Victoria has narrowed that down in about 2015, the law narrowed down to give certain categories of people the power to make a claim against an estate for further provision, and tightened that right up. So now it's only really a spouse and children and people who are financially dependent who can make a claim against an estate for further provision. So what that has caused is that many more people are now looking at the will itself, both to see if it is valid, and also wanting to make sure that any ambiguities are cleared up. Previously, people would just make a family provision claim, but now we're getting far more legally technical in making claims because not as many people can make a claim. So essentially, tonight we're talking about the areas of law where a will can be disputed not on the basis of a lack of provision for someone. So one of the categories tonight that we're talking about is ambiguities in a will. So quite often, ambiguities arise because of poor drafting and the poor use of words, particularly when people make homemade wills because they just don't understand how the law defines things. And also quite a lot of particularly suburban lawyers who do really cheap wills because they've been using the same will precedent for about 30 or 40 years, and they're not doing good work, basically. So this often happens when in a will, a group of people is defined by a certain word, like children or grandchildren. So where someone says, I leave my residue equally to my children, but prior to that, I also give $10,000 to each of my grandchildren. So that's exactly what happened in a case that I'm going to talk about first in Victoria in 2017. So not long ago, Stroughton, it was the estate of Stroughton, and there was wills done by a husband and wife, and they were mirror image wills, but they were a blended family. And so they left everything equally to their children, but like I said, they'd also left a legacy to each of their grandchildren. So you can tell that a blended family, one, like the mother would have her own children, and then her children have had children. And then the father had his own children, and then his children had had children. So I think it was dad who died first. So everything went to mum. And then mum's will said a legacy to grandchildren and then equally to children. So did the term grandchildren only mean her children's children, or did it mean the grandchildren of both? And the law and the court determined that it meant the grandchildren of both. So even though the husband had already passed away, her stepchildren and step-grandchildren were still within the definition of grandchildren. And likewise, the residue was left equally to children, and that wasn't just her children. That included children and stepchildren. So a lot of people don't realise that the definition of child includes stepchild and adopted child. not necessarily foster child though. So if you want it to include foster children or exclude anyone, you need to say so specifically. But then interestingly, again, the definition of grandchildren included the grandchildren of both the husband and wife. So that was an ambiguity that went all the way to the Supreme Court for judgment. The next case is about a specific clause. And this was in court only this year, 2019, the judgment came down. So an old fellow died, an old Italian man, and he appointed his partner and his son. And the whole residue was split between his partner and his children. Now, the issue was that there was a clause that left $200,000 to a nephew of the old Italian fellow. And the wording was, for the sole purpose of enabling him, being the nephew, to construct a family crypt in my name in a cemetery in Italy. So that was the clause. Now, obviously, the partner and the son didn't really want $200,000 going for such a thing. So it was brought to the court to determine, what does this clause mean? Is it valid? So, I mean, on the face of reading that, it's not very well worded, but if the partner and the son weren't upset about losing $200,000, they would have made it happen and made something work. Because they didn't want that to happen, they brought it to court and the court analysed the clause. So the court went through it, and the court first said that, well, it's not a gift. So the nephew is not getting $200,000, right? It was, the money is for a purpose. So it wasn't the nephew's, so it's not a gift. So clearly the purpose of the $200,000 was not a charitable purpose. So it wasn't going to a registered charity or a community organisation for a charitable purpose. So it wasn't a trust for that reason. So the court said, well, it can only be a non-charitable purpose trust. So let's work out if it's clear enough to be a non-charitable purpose trust. So firstly, the court went, well, what is family? So remember, the clause said the $200,000 is to the nephew for the sole purpose of enabling him to construct a family crypt. Who is family? So does family include his partner and his children? Is family broader than that? How many people are supposed to be in this family? How big is the crypt supposed to be? Is it supposed to be 20 coffins? Is it supposed to be immediate family? If the nephew's doing that, then maybe it's supposed to be extended family. It just wasn't defined. Then the court thought, well, the other thing the clause doesn't take into account is, what if other family members are not willing to go into this family crypt? So it's expensive to send someone back from Australia to Italy, particularly as a whole body, not as cremated. And what if they wanted to be buried elsewhere with their spouse, potentially in Australia? Or what if they wanted to be cremated and scattered? So this old fellow who died couldn't compel other family members to be part of this family crypt. The court then wondered, well, did he mean that he wanted to move some existing people in his family that were already dead and put them all in one place? Did he want to consolidate people who had been buried all over the place and bring them all together? Again, ambiguous. It didn't say. And the other thing was that the court thought, well, the wording also could mean that the $200,000 goes to the nephew for the purpose of enabling him to construct the family crypt. So did that mean that he had to do it? Or was he project managing and engaging other people? So I think in a lot of ways the court found ambiguities because the family wanted to find ambiguities, and essentially that whole clause was found to be invalid. So the $200,000 didn't go to the nephew, and there was no family crypt built, and the spouse and kids got the 200,000 between them. Another case, this was in Victoria Supreme Court in 2018. Not so much ambiguous, but still really interesting. And in fact, as it today, I don't think it's been determined by a court. It may have settled otherwise. So this essentially was a summary judgment. So again, we've got a blended family in this situation. So we've got a husband and wife. He had a daughter, she had a son. They married, but then they were separated, but they were still good friends apparently. So the old fellow passed away and left his whole estate to his ex-spouse and her son, and nothing to his own daughter. Now, he also gave the spouse power of attorney, and her son also gave her power of attorney. So mum had power of attorney for both ex-husband and her son. Essentially, the estate of the old fellow was just his house. But what the wife did while the old fellow was still alive was use the power of attorney to transfer the old fellow's house to her son. So she signed everything for the old fellow, and she signed everything for her son, both under powers of attorney. So she did all this without independent legal advice. And so she claimed that it was what the old fellow wanted. So essentially there's nothing in the estate. So the daughter takes issue with this. There's no point in her making a family provision claim in this case because there is no estate, right? So what she tries to do is say that the wife acted under a conflict of interest under the power of attorney to get the transfer of the house set aside. And the court threw it out. So there wasn't enough suspicion around the circumstance for her to raise a case. Now, it may have continued, but that is as far as we've had public judgment on that case. So interesting one. So those are three cases on ambiguity. There where you can see quite a few different ones. There's been a really ambiguous clause. There's been ambiguity in relation to the class of children, grandchildren. And then there's been ambiguity around what's in the estate with this last one, whether the house is in the estate or not, based on the behaviour of the attorney. Now we're going to move on to wills that have been found to be invalid. So this is a bigger area. So let me just jump straight in. So the first case was actually a Queensland one in 2017, sorry. And this case actually had the whole country buzzing, well, in terms of solicitors anyway, because it was quite interesting for us, and it hasn't been repeated anywhere else as yet. So it's a case of Nickel. So Mr. Nickel suicided. He had an on-off girlfriend, no kids. When he suicided, he was found near his phone. His phone had an unsent text message addressed to his brother. And the text message said that he wanted his brother to have his house and his super, and his partner just to take her stuff. He had initialed the text, he'd put his date of birth, and he'd called the text "My Will," but he hadn't sent it. So it was invalid for a number of reasons. It was invalid because, no, I shouldn't use the word invalid. So it was not correctly signed, obviously. So it wasn't signed that like a will needs to be signed for it to be a valid will. He didn't sign it. He didn't have two witnesses. However, the court still found that it was his testamentary wish. So the court found that it was a valid will, a text message. It was in writing, and it was obviously done when he was thinking about dying. So the people who were trying to claim the will was invalid, that the text message wasn't a valid will, firstly said that he wasn't in his right mind, because someone who suicides can't be mentally sound. The court found that wasn't the case. The court found that wanting to suicide is not sufficient mental disturbance to make you be not have testamentary capacity. So he still had testamentary capacity, even if he was so depressed as he wanted to die. And the other thing that was tried to be argued was that because he didn't send it, he didn't actually mean it. But the court found that the sending of the text didn't invalidate his intentions. In fact, the court said that if he had sent the text message, it would have been a warning to his brother, and his brother might have arrived and stopped him from killing himself. So, very interesting case. Text message unsent was determined to be a valid will. Now, interestingly, I think that a lot of these decisions might come down to how the witnesses appear, because I think really that the court probably liked the brother more than the partner, and so made the arguments enough to make sure that the brother got the house and the super. So next invalid will was an informal will. This was in court in Victoria in 2017. So there was a formal will in 2008, so properly signed, all good. The 2008 will didn't provide for the stepdaughter. But then when the family tried to prove and get probate on the 2008 will, and you can see that the death was in about 2009, and this only came to court in 2017. So there has been 8 years of fighting over this, right? What a waste. Anyway, when they tried to prove the 2008 will, the stepdaughter came forward and said, oh no, hold on, I've got a will that was written later, and produced a will in 2009 that was handwritten and informal, so it hadn't been properly signed. So again, I think this is a case where the court really didn't like the stepdaughter and her husband, so the court really criticised, the judge was really judgmental about them keeping this later handwritten will secret. But then they got deeper into it. The court found that the deceased who had died was really elderly and vulnerable, and the stepdaughter had gotten back into his life and had handwritten the will for him. So that was suspicious. Found how much of an influence the stepdaughter was over the deceased. And also the deceased had been in a nursing home, and absolutely no one in the nursing home or the doctors knew about the informal will, or that the deceased had changed his wishes or anything like that. So it's not like he was going around talking about wanting to change his will or about having changed it or anything. So it was a complete secret. So the court was not persuaded that the 2009 will was valid, and so stayed with the 2008 will that left the stepdaughter out. Next one. Now, this was an unfortunate estate planning situation. So many people don't realise that when you get married, it invalidates a will that was done prior to your marriage date. So This case was in the New South Wales Supreme Court in 2018. It was the second wife who came to court. So there was a will done, but the will was done prior to their marriage. So basically she came to the court to ask the court a couple of things. So firstly, whether the court will agree that the will prior to the marriage was still valid. But the court found that no, the marriage invalidated the will. So they were together when he made the will, but they hadn't been living together and they hadn't committed to marrying at the time he did the will. So the court couldn't find that he'd done the will in contemplation of them having married. So no will. And the other thing that was going on in this family was that he had a self-managed super fund, and the self-managed super fund had become deadlocked because the second wife and one of the children were trustees of the super fund, and neither of them could agree about who to pay the super to. So her other application to the court was that because she was the only tax dependent out of the family, the super should be paid to her. But the court, again, didn't agree with that. Under the legislation, the court said that the super fund can pay it to any super dependent. Doesn't matter if they're a tax dependent or not, because the court is not about tax avoidance. So again, this is one that is probably still being fought over because particularly the super, it was deadlocked. I can't see how they're going to undo that deadlock, or because estate planning wasn't done properly. And the final case I wanted to talk about under invalidity is more testamentary capacity issues. So this is a really elderly person again, and this was in the ACT this year, 2019. A new will had been signed by this elderly man just prior to dying. So he'd given everything to his niece, who again had weaseled her way in when he was vulnerable and sick. So the new will excluded his wife and his daughter, and his old will had provided for his wife and his daughter. So he'd been married for 50 years. The change in the will was unprecedented. The niece tried to assert that there was mistreatment of the old fellow by his wife and his daughter, but there was no independent evidence of that. So it was only the niece's say-so. There was no documentary evidence from any third parties, from anyone in the nursing home, from any doctors, nothing. No other family members said that there was any mistreatment. And there was also actually some medical evidence that was brought by the wife that the old man had been having hallucinations prior to dying when he was pretty sick. And so there was a finding that there was altered behaviour. So there was medical notes that his behaviour was being altered. So the court found that the will just prior to his death was illogical, and that he didn't have capacity. He didn't know what was going on anymore. So the new will that gave everything to the niece was set aside, and it went back to an old will for the wife and the daughter. So in this scenario, I think that the court got it right, absolutely. So again, there's a case of someone trying to intervene and muddle with the estate planning process. And it's something solicitors really have to be aware of. But quite often, as you see, there was the informal will made by someone in handwriting. They obviously didn't get legal advice. So it's people who are trying to do dodgy things towards the end of someone's life often don't use a solicitor. So moving on. So this category, I suppose, is a little bit of a combination of the other two in some ways. So I've just got 3 cases to talk about where we've got someone trying to claim that a will is valid and the court's determined that they're incorrect. So the first case was in Victoria in 2016. So this is the oldest case we're looking at. So, 2.5 years ago or so. So this was in the matter of Lynch, and it was about a stopgap will. So the old fellow who passed away had prepared a handwritten document. Now, it consisted of 3 pages. The first page appointed executors, the second page appointed beneficiaries, and the third page actually listed out what the assets were and who they went to, which is bizarre. The first page was signed by the old fellow and by one friend. So it wasn't signed properly. He didn't sign the other pages. And he'd actually done this handwritten thing when he'd been admitted to hospital for heart surgery. And that surgery had been like 10 years before. Now, the 3 pages weren't all done in the same pen, so it wasn't clear that they were all done at the same time. And there weren't amounts put in correctly either. So it was really an unclear document. It wasn't even clear if all the 3 pages were meant to be read together or there was supposed to be like an underlying direction. So badly done. But not only that, because it was done sort of in an emergency situation right before this guy went into heart surgery, and he obviously survived the heart surgery and lived for another 10 years, the court found that he had plenty of time to do a will. So there was no way the court was going to rely on this stopgap will. So probate was refused on that will, and he was essentially intestate because there was no will. So again, really poor planning. The estate of Tang was an interesting one. This was in Victoria in 2017. So it is an Australian citizen who died in a hospital in China. And this one, the court actually allowed the little note. So in hospital, Mr. Tang's mother came to visit, and Mr. Tang wrote out some information about his Australian bank accounts, wanting them to go to his mother. Now, the Chinese courts would not recognise that note, and besides, it was an Australian asset anyway. So she brought the note back to Australia, and the Australian court actually recognised that it was enough for a will. So really interesting one. So that was 2 extremes, I suppose. One stopgap will that had been done a long time ago, which was found to be invalid, and then another done in hospital, but the guy actually died, and it was just a note that was found to be a proper testamentary wish. And then the final situation that I wanted to talk about, again, which is just really bad estate planning, is a matter in the Western Australian courts in 2018, so last year. So this was, again, a blended family. So I don't know why blended families aren't doing their estate planning properly. So he had a second wife. He had no will, and he'd jumped around from job to job a fair bit, and he had 4 super funds. So in this one, in fact, the second wife got herself into a bit of trouble. Under intestacy, she would have been fairly right to have most of the estate. I don't know if there would have been a claim against the estate or not. But I suppose the way the family made a claim was to stop her getting all the super, because she had to administer the estate. The court found that she had a conflict of interest if she applied for the superannuation directly and didn't apply for it as the administrator of the estate to come into the estate. So her conflict of interest was that she was avoiding the super coming into the estate, so it couldn't be claimed against. So quite an interesting one. So super that was paid to her directly, she had to repay into the estate. So again, really poor planning. Really, really poor planning, but also some bad advice given to that woman too. So there we go. I've run through 10 cases trying to convince you that estate planning must be done correctly. And look, a lot of people don't do the estate planning because they're at the bottom of this triangle. They're overwhelmed. They're stressed about having to do it. They don't know how to do it. They don't even know where to start sometimes. So they're feeling exhausted and it's all too hard. But once they start doing research, like you're doing by watching this webinar, and they're exploring and they're finding out what they need, it's starting to become more possible. So they're getting started, becoming proactive, and then when they finally do the estate planning, they've got absolute certainty, control, and they are protected. And this is how we find a lot of people who go through estate planning with us. And look, the steps with us is really easy. 5-step process. 2 steps you're actively involved in, which are the appointments. So when you're ready, we make an initial appointment and we send you some initial info before that appointment. So you come into your first appointment, you've got some things prepared, but not too much. First appointment, I collect all the information I need. If there's anything you don't have or don't know, there's plenty of time until this next appointment for you to get that to me. So I draft all your documents between the 2 appointments and send you the drafts and ask you for any other information that I need. Second appointment, everything's signed. You're done, you're protected, it's finished. 2 or 3 weeks between the appointments, so all done. There's still time before Christmas. And then we finalise everything. We make sure all the attorneys have signed their acceptance pages. We make sure binding death benefit nominations are sent into super. We keep everything in safe custody for you for free, and we send you a pack of certified copies for you to keep at home. And we can send electronic copies to you as well. So what does it all cost? For a couple, it costs you less than your annual house and contents insurance, and it's not even something you have to pay for every year. It is something that you do once every 5 years, sometimes once every 20 years. So you're looking at just over $1,000 for your full estate plan done properly. If you're not sure whether you actually need it done or you want some advice before going ahead, you can book a family situation review with us. And for those who actually watch this webinar, if you contact our office, we'll give you that family situation review for $295 instead of $450. If you come in for your family situation review and then you actually decide to go ahead and do your full estate plan with us, we don't charge you the $250. We just roll it into the whole cost, right? So that's it for tonight. Thank you so much for sticking with me. Again, my name was Jacqui Brauman, and TBA Law is where you need to come. So I'm going to stop the slide share and just quickly cross back to the screen where I can see the participants and questions. And just having a look to see whether anyone has asked a question. So there's nothing in the chat box, in the Q&A box, nothing in there either. Okay. So I'm going to leave it there then. You're quite welcome to email me afterwards. You can email admin@tbalaw.com.au or directly to me, Jacqui@tbalaw.com.au, if you have a question. Otherwise, I thank you very much for attending, and I wish you a great weekend. Have a good evening. Thank you.